Good morning. I'm Lucy Beednell with the Arc of Northern Virginia, and we are very excited to be here today with Dana Traynham from the Disability Law Center of Virginia. She and dLCV are tremendous resources for lawyers who are absolute experts on guardianship, alternatives to guardianship, how it makes sense to preserve rights and navigate these kinds of things. I am absolutely thrilled to be hearing from her today. I can't get enough. So we'll turn the mic over to you. Take it away.
Thank you very much. That may be the nicest introduction I have ever gotten. Well, good morning. I wish I could see your faces. I miss seeing faces when I do these sort of things, but good morning. I know there's bright and shining faces out there. Today, we're going to talk about the title is How to Decide Who Decides When I Can't Decide. Decision-making options in Virginia. Decision-making options for folks who need help making decisions. And guess what, folks? That's all of us. We all sometimes need help making decisions. And we're going to talk about planning for a time in our lives when we may be unable to make decisions or communicate decisions for ourselves. And how can we protect ourselves in situations like that? Let me see. Okay, so I want to make sure that we're all using the same vocabulary, we're all using the same words, and they all mean the same thing. First off, one of the most important words that we need to understand and that you're going to hear a lot today is capacity. And capacity is the ability to make decisions and to communicate those decisions. And we're going to go into that a little bit deeper. We're going to do a deeper dive on that after we do this just very general vocabulary lesson. When I talk about planning for a future time of incapacity, so planning now for a time when maybe in the future I will not be able to communicate decisions for myself because of an injury or an illness. Um, I think of advanced directive as being an umbrella term. It's the very general term that means I am planning for that future time when I may face that situation where I'm not able to make decisions for myself. How do I want those decisions to be made? And so under that umbrella are many different choices, and that's what we're here to talk about today, the decision-making options that we have in Virginia for that time in our lives. The first one is power of attorney. In a power of attorney, I can name a person to make decisions for me if I'm ever in that situation where I cannot make decisions for myself. Where again, all these words we're going to all go into, these terms we're going to go into a deeper dive later, but this is just the basic vocabulary. Living will, that's when I put in writing what sort of care or treatment I want when I'm at the end of my life. My death is imminent. Either I have an incurable illness or an incurable injury. Death is imminent. How do I want, what sort of care do I want or not want at that time in my life? Medical directive is I can put in writing now what sort of care or treatment I want or don't want in a future period of time when I'm unable to communicate that to my doctors. Psychiatric advance directive. The majority of states now have a psychiatric advance directive embedded in their law and statute. Virginia actually does not have a psychiatric advance directive in statute. We were the first state, and I don't know if we're still the only state. We have an integrated advance directive, meaning that we don't have a separate law for a psychiatric advance directive. So I can put in my own medical directive, in my own, my power of attorney, the person I choose can make my medical decisions as well as my psychiatric decisions. Virginia was very innovative in doing that. So let's talk a little bit more about capacity, that very important word. So this is the best definition that I have found for capacity that really breaks it down. In order to have capacity to make a decision that I need to make, I need to be able to take in information, make an informed decision using that information, and then communicate my decision. A lot of times when people talk about capacity, they want to focus on number two, that making an informed decision. And they may even say capacity means the ability to make an informed decision. But I'm here to tell you that I believe that number one and number three are the most important things for us to talk about as people who advocate for folks with disabilities, especially those with cognitive and intellectual disabilities. Number one and number three, hold on, folks, let me turn off this phone because I don't know about you guys, but man, I get spam all the time. Let me turn this off. So again, when we are advocating for people with disabilities, number one and number three is so important for us. The ability to take in information. And by that, sorry, that's my secretary barking in the next room. In order to take in information, the person needs to be given that information in the way that they can best receive it. So a very obvious and silly example is if the doctor comes and gives me information in Spanish for a decision that I need to make, well, I'm not going to understand what that doctor says. Does that mean I don't have capacity? No, it means that doctor failed to give me information in a way that I can take it in. And so when we're talking about working with people with disabilities, those with intellectual and cognitive disabilities especially, they need to be given information in a way that they can take it in. And they may communicate differently. They may need things explained in a different way. They may need to be given the information in more than one setting. They may need longer time to process that information. So as advocates, as parents, and as professionals, as advocates, working with folks who are talking to, here I'm talking about healthcare, but it could be any type of decision, but advocating for that person to get information in a way that they can understand it. Then making an informed decision based on that information. And then number three is also so important. Communicate your decision. I work with people every day that communicate in different ways. They may communicate verbally. They may communicate non-verbally. I have worked with people who communicate by eye gaze, by pointing or gestures, by using an OGCOM device, many different ways to communicate. Folks who use an ASL interpreter, grunting, pointing, I mean, you name it, people communicate in different ways. And so as an advocate, as a parent, advocating to listen to the individual who's communicating. A lot of times, if they're not communicating verbally in a way that a doctor or another professional can understand right away, they will just assume the person lacks capacity, but that's often not the case. We just need to understand the way that they're communicating. In Virginia, capacity is presumed. So when I go to meet with someone, I don't care before I meet with them what their diagnosis is, their IQ, whether they were in special education or not. I don't care about any of that. I go into a meeting assuming that person has capacity. Virginia law says that a person has legal capacity to make decisions for themselves as long as they were over the age of 18 and they have not been declared incapacitated. So a person has capacity until they've been declared not to have capacity. That's how our law is written. How does a person become declared incapacitated? We have two different ways that happens. The first way is a clinical determination of incapacity. So let me give you a little scenario that kind of explains a clinical determination of capacity. I go to a doctor and he says, Dana, you have a new diagnosis and these are your treatment options. The doctor may then ask me questions to evaluate, to gauge whether I'm understanding what is being said. If he thinks Dana's not getting this, I don't feel comfortable that she can make this decision. At that point, I still have capacity because in Virginia, it takes two doctors to say that I do not have capacity. So my treating doctor would then ask another doctor who is not my treating doctor, who is a doctor who may not have even know me, to come in and meet with me in person and determine by asking me questions and talking to me whether that doctor also feels that I do not have capacity. If both of those doctors say Dana is not getting this, she is not understanding it, then at that point, I do not have the clinical capacity to make the decision that needs to be made, and an alternative decision maker will have to be found. And that's what we're talking about today. What are the options when an alternative decision maker has to make a decision for us? So we're going to get into that. So that is sort of the clinical route to determining capacity. There is another route, and that's the legal route. That is when a court determines whether the person has capacity or not, and that's done in a guardianship proceeding. Someone petitions the court, says, I don't think Dana is capable of making decisions for herself, and I want the court to determine she does not have capacity and appoint a guardian for her to be making decisions. So those are the two ways that capacity is evaluated and determined in Virginia. If neither of those things has been done, then the person still has legal capacity to make decisions for themselves, regardless of diagnosis. Now, a lot of times people see capacity, and I see this a lot in professionals. Capacity is an either or, it's a yes or a no. So, but it's not. It is so not a yes or no thing. It's very fluid. So if I see a sentence in a medical chart, or if someone says to me, Dana lacks capacity, it's a little pet peeve of mine. That's an incomplete sentence. I lack capacity for what? And when I talk about capacity being fluid, time and circumstance, sometimes it makes a difference where I meet with a person. How many times have I met with that person? What time of day is it? Some people, their capacity waxes and wanes throughout the day. It is very fluid. It changes. Different levels are needed for different decisions. So I have developed a spectrum because spectrums seem to be kind of the thing now. We kind of are starting to understand as a society that we're not really a black or white society. There are a lot of gray areas. And so there are spectrums for things. And I believe capacity is on a spectrum. And I call it the peas to brain tumor spectrum. I'm going to be famous for this one day. I'm going to write a book or something, but it's peas to brain tumor is the spectrum of capacity that I have created. So if you were with me right now, you would see me pointing all the way down to the floor. That's the P level of capacity, very low level of capacity. And the reason I name it P's is because my children at a very, very young age were able to take in information, make a decision, and communicate to me very clearly that they did not like peas. My daughter, her record is 4 peas in 1 nostril. She definitely was able to communicate to me, I don't like these peas. I'm going to put them anywhere other than my mouth. My son had another way of communicating to me. He would feed them to the dog. So at a very young age, we have capacity to make decisions for ourselves. And we definitely have the capacity to communicate those decisions. Spend any time with a child, and even if they don't have words, they definitely communicate whether they like something or not. So that's the low level of capacity. Now I'm pointing up to the ceiling and I'm talking about the brain tumor level of capacity. That's when I'm sitting in my doctor's office and he says, Dana, you have a brain tumor. We have 4 courses of treatment that we can try. And there are pros and cons to each one. Now, my level of capacity to understand that is going to be pretty high. I'm going to have to really be able to understand the nuances of those different treatment options. And I believe that every decision that we make throughout the day falls somewhere between peas and brain tumor. The problem I have a lot of times with capacity determinations by medical professionals is that if someone doesn't have the P level of capacity, then they'll write Dana lacks capacity. And that's my pet peeve. Capacity for decisions is for different types of decisions is different. So if I were in the room with you, I would ask you your opinion on what do you think the capacity level is for doing an advance directive, for choosing someone to make decisions for me if I can't. I believe it falls much closer to peas than brain tumor because If I'm doing just a power of attorney and I'm just saying who I want to make decisions for me, if I can't, that level is pretty low. I just need to know, hey, I want that person talking to the doctor for me. I want that person signing documents for me. Um, and I have been able to help folks write powers of attorney that were just able to point to someone and indicate who they want to make decisions for them when they can't. Our law says that the doctor must say when writing the note about capacity, does the person lack capacity to make a particular healthcare decision, a set of healthcare decisions, or all healthcare decisions? Now, the specified set of healthcare decisions, it might say Dana lacks capacity to make decisions about treatment for her newly diagnosed brain tumor. Okay. I may be able to still make decisions about whether I take a multivitamin every day or if I take my blood pressure medicine. But when it comes to that particular set of healthcare decisions, I lack capacity. Unfortunately, I see a lot that it just says all healthcare decisions. The person lacks capacity to make all healthcare decisions. These are things that we really need to watch out for as advocates for folks with disabilities. So, who are the decision makers in Virginia? What are the options? Now, I am the expert on me. I am the expert on my health care, my health history. So I am the best person to make medical decisions for myself. But what if I'm in a situation like we've talked about where I have an injury or an illness and I can't make decisions? Either I can't take information, I can't make a decision, or I can't communicate that decision. So I don't have capacity. Then who is the best person to make those decisions for me? Well, guess what? It's still me. I am still the best person to make those decisions. And I do it by advanced planning. I do it by making an advance directive, by either naming a person who I know is going to speak for me and be my voice when I don't have one, or I'm going to do a medical directive and I'm going to put in writing what sort of care or treatment I want or don't want, or I'm going to do all of those things. So I am always the best person to make decisions for myself. I just need to do some advanced planning to make sure I don't lose that right and that ability to make those decisions for myself in times of incapacity. Now, if I haven't done an advanced directive and I am in that situation where I am no longer able to make decisions for myself or communicate my decisions, then who is the best person to make decisions for me? And Virginia law through the Healthcare Decisions Act says that the next best person would be next of kin, a family member. And the law goes out to specify who is your next of kin. It has a hierarchy of folks who can make decisions for you if you're in that situation. And that is, it's a legal hierarchy, meaning you don't jump over people. If a person is in a higher level, then they will be making decisions for you, even if they may not be the best person to make a decision. So that's why if you really want to choose who will make decisions for you, doing an advance directive is the way to go. So in the Healthcare Decisions Act, the law says that the very first person the doctor will go to is my spouse. If I am legally married in Virginia, then my spouse will make decisions for me if I cannot. Just a couple of things here. Virginia does not have common law marriage. We do not recognize common law marriage. So I may have lived with someone for 50 years. We raised kids together. Everybody thinks we're married. We argue like an old married couple. We raise children together. But if we are not legally married, then that person will not be making decisions for me and could very well not even be allowed to visit me in a hospital setting if it's family only. That person would be considered a stranger in the law. Also, on the other end of the marriage scenario, I am married to a person until something has been filed in the court to end that marriage. So there are people who haven't lived together for 20 years, but they never went through the process of becoming divorced. Under Virginia law, they are still married, and that person would be making healthcare decisions for the other person in periods of incapacity. So first will be my spouse. Second, if I am not legally married or my spouse is unavailable, maybe we were in the same car accident, so my spouse is unavailable. The second down the line would be adult children. If there's more than one, most people say, oh, then it must be the oldest would make the decisions, but that is not correct. Under Virginia law, it says that if there's more than one person in any of these levels, any of the hierarchy, then the doctor may go with the majority. So I would say a very good piece of legal advice here is to have an odd number of children, right? Because otherwise you get a tie. So, but seriously, when you have more than one person in a hierarchy level, this is where families can really fall apart. This is where you get some infighting, and you may see sides of people you've never seen before. So in order to keep peace in the family and make sure your wishes are followed, do an advance directive, plan for these things in the future. So, a few things about children. They must be adult children. They must be my legal children, meaning either I gave birth to them or I adopted them. Stepchildren do not count in the equation. Foster children, my son-in-law, daughter-in-law do not count in the equation. Okay. It's my legal children have a say in what happens. The third down the line would be parents. Next after parents would be siblings. And again, if there's more than one, majority may rule. And after that comes, if I don't have living siblings, then it goes down to next available blood relation. Here we're getting into aunts, uncles, cousins, nieces, nephews, anybody that the doctor can find to make decisions for me. So again, just know that the best way is to name someone to make decisions for you in this situation. So we never have to go through this hierarchy, and we never have to go through people maybe arguing and not agreeing on what's best for you. I also want to, I don't know if anybody has noticed, but I've really emphasized the word may. The doctor may go with the majority, and that's the way the law is written. So whenever the law says may, it's just, that means may not. So if the doctor does not feel comfortable going with the majority, and that usually stems from not wanting to get sued by the other side, or maybe not agreeing with what the majority is saying, the doctor can always take it to court and ask the judge to make a decision. I don't know about you guys, but I do not want a judge making my healthcare decisions. So I'm really going to put these things in writing ahead of time through doing an advance directive. Okay. So the so may is a word that, signifies that there's a may not. When we're talking about advance directive, the law says the doctor shall follow the wishes of the individual that's in the advance directive, meaning they don't have a choice. So again, doing an advance directive, putting these things in writing ahead of time, is a much better protection than just saying, oh, my family will make the decision for me. Other decision makers in Virginia, if a person is living in or receiving services from a program that is licensed by the Department of Behavioral Health or Developmental Services, they may have an authorized representative. That authorized representative is appointed by the director of that DBHDS licensed program and only makes decisions about treatment and care in that program. So it's very limited. So if a person is living in, let's say, a licensed group home, and the authorized representative makes decisions about what happens in that group home, if the person needs to then go to the emergency room for a medical emergency, that authorized representative has no say what happens in that medical setting. So it's very limited. We've talked a little bit about guardianship. A person only becomes a guardian of an adult through a court process, and there would be a court order appointing somebody else to make decisions for that person. I've spoken to a lot of parents over the years who assume they're the guardian of their adult child with a disability because they've always made decisions for that person. Um, but if they do not have a court order, they are not the guardian of the individual. And like I said, the judge can always do an order for treatment for someone who needs medical treatment. So again, we have this umbrella term of advanced directives, and within that, we can do a living will about how, our end of life care. We can name an alternate decision maker through a power of attorney, and we can write down what sort of care or treatment we want in a medical directive. These are all different options we have. And it is an a la carte menu. You can have all of them, you can have some of them, you can have one of them. You choose what is best for you. A living will is used only for end of life decisions, and usually you're talking about whether you want extraordinary measures or, do you want life support? Do you want the doctors to keep you alive in any way possible, or do you want comfort measures until sort of nature takes its course? When I talk about end of life in Virginia, the law here also covers folks who are in what's called a permanent vegetative state. I hate that terminology, but that is the terminology that's used. So if I'm in a permanent coma type state where I'm not aware of my surroundings, how do I want, what sort of care or treatment do I want or not want? I put that in writing in a living will. Under power of attorney, you can have a healthcare power of attorney, which is mostly what I'm talking about today. You can have a financial power of attorney, so I can name someone to make financial decisions for me. And I can have an educational power of attorney. If my child has an IEP, when they turn 18, there's a transfer of rights. They get their educational rights transferred to them as an adult when they turn 18. But maybe maybe I'm 18 years old, I have an IEP, but I still want my parents at the table. I still want them to be involved in the decision-making process, and I still want them to, sign the IEP and help me make those decisions. I can have an educational power of attorney. So in a power of attorney, when I'm choosing someone to make decisions for me, that person I choose is called my agent. So when I'm choosing an agent, I'm going to be looking for some qualifications for that person. First and foremost, complete trust. This person is going to step in at a time when I am very vulnerable, unable to make my own decisions about possibly life and death. And so I want somebody that I really trust. I also want someone who's willing to do it. Some states require the agent to sign the power of attorney document saying that they're willing. Virginia doesn't require that, but I don't think it's necessarily a bad idea. You want the person to, number one, be willing to do it, and number two, know that they've been named. I don't want to get a phone call at 2 o'clock in the morning and say, hi, so-and-so's in the hospital. We need some decisions to be made, and you're named as the agent and a power of attorney. And I'm like, what? I had no idea. So you want them to be willing and able to do it. Are they available in this mobile society? Almost everybody is available 24/7. But availability is something that you want to think about. Alternate or co-agent. I want to talk about that just for a second. I recommend one, and one I absolutely discourage. So let's talk about the one that I discourage. That's co-agent. That's if I say, if anything should happen to me, I want to name as my agents Nancy and Christy, and I want both of them to have the power and authority to make decisions for me. Think about for a second any problem that could occur if I name two people to do the job. They may not agree. And if they don't agree, then we have a problem. And I may have just totally created a problem that negates my power of attorney because they don't agree, and so a decision can't be made. I highly discourage co-agents. I think everybody should have a job, and one person should be in charge of making decisions at a time. Alternate decision makers, that is something that I highly encourage. So that would be if I am incapacitated and unable to make my own decisions, I want Nancy to make those decisions for me. If Nancy's not available, then I'd like Christy to do so. I can have as many alternate agents as I choose. So I do recommend alternate agents. Um, some other things to think about, to the person that I'm thinking about, do they have this, they share my beliefs, my value system? And if they don't, are they able to be my voice and do what I would do and not what they think is the best? Um, I want the person who is my agent to be my voice and speak with my voice and make decisions based on what I would do, not what they would do. Once I've chosen my agent, I then decide what sort of powers do I want them to have. It can be very general. I can let them say, okay, they can make all medical decisions for me, everything. Or I can be specific. I can say, you know what, I don't want them to make end of life decisions for me because I already have a living will. I want them or don't want them to make decisions about who can visit me if I'm in the hospital setting. What about organ donation? Do I want them to make that decision? Do I want them to be able to admit me to a psychiatric facility if I need that? Do I want them to be able to, when I lack capacity, but I'm still protesting something, do I want them to be able to sign for that treatment, even if I'm saying no at the time when I'm not understanding what I'm saying? I can give them that authority. Do I want my agent to have the authority to agree to medical research, clinical trials, that sort of thing? I can be very specific like that, or I can just be general and say they have the ability to make all decisions for me when I can't. Medical directives, that's when we put in writing what care or treatment we want or don't want. So I think of a medical directive as being you're sitting down, you're writing, you're putting in writing everything you would tell a new doctor if you were to meet with that doctor. So you say you're on vacation and you get hurt, you go to the hospital. So you're seeing a doctor you've never seen before and they don't know you at all. Um, if I am able to speak to them, I can tell them my medical history. I can tell them what sort of things I want and don't want. What are my values when it comes to healthcare? But if I'm not able to speak to them, I can put that in a medical directive so they have that information, even if I'm not able to communicate it to them verbally at the time. When I do a medical directive, the sky's the limit pretty much here because Virginia doesn't have a form. There's no magic form out there. There are sample forms, and we have some on our website that I created with line by line instructions on how to do them. So, but there is no form. The kind of the joke is you could write an advance directive on a napkin, and as long as it's signed in the presence of two witnesses, it's legal. I don't recommend it, but so the choices you can put in a medical directive, these are just some of them. What sort of what hospital do I want to go to? If I have a choice and maybe there's a hospital, please do not send me to this hospital if at all possible. I want to work with this doctor. I really don't want to work with this doctor. I agree to these medications, but I refuse these medications. Do I, want ECT if I have a mental health emergency, experimental studies, drug trials? I mean, it just goes on and on. Whatever is important to you and your healthcare and your value system, you can put in a medical directive. In Virginia, you don't need an attorney to uh, um, fill this out. Okay. I say no attorneys necessary, but recommended. Not necessarily, not anymore. Probably should take that out because there's so many forms out there now that I don't think you really would even be recommended to see an attorney. Never hurts. But then again, I say if you can keep lawyers out of your life, that's all the better. We have forms on our website. We have a form for a fully integrated, the advanced directive that includes everything with line by line instructions. And then we also have a power of attorney, again, with line by line instructions that you can use without having to go through an attorney. What Virginia law does require is that it be signed by the person executing it in the presence of two witnesses. So those witnesses have to be in the room when the person signs it. So there have to be at least 3 people in the room when it's signed. Notary is optional, but this I still recommend. I recommend it be notarized, but it is not required in Virginia for a healthcare power of attorney or advance directive. If you're getting into some complicated financial things such as buying and selling property, then yes, a notary is required. But if you're getting into that sort of thing and you're getting into high dollar items, then you probably should be seeing an attorney anyway to write that up. But just know a notary is not required in Virginia, but it is recommended. Once you have it in place and it's signed in the presence of two witnesses, it cannot be a secret document. It has to get out there. People have to know that it exists. You definitely want your agent to have a copy, all of your doctors. You can register it with your local hospitals. You don't have to wait until you're a patient. We have a state registry in Virginia. This is free. And the contact information for that is at the end of the PowerPoint. So you can register it. They send you an ID card that you keep with your driver's license or ID. Family members, others that need it. Once you're sending out all of those copies, make sure you keep track of who has copies. If you ever want to make changes to it or revoke it, you want to make sure that everybody who has a copy is aware of any changes. Revoking it is easy. I'm going to skip over this part because I think the information I have here is covers it pretty well. I understand Lucy has already gone over supported decision making, so I'm going to skip over that. But I haven't done any of these things. We've talked about, then it gets to next of kin, court order treatment, guardianship. We want to avoid those things, right? Because we want to make decisions for ourselves. Guardianship, when we're looking at guardianship, we've talked about that's the court process where the court determines capacity. And then if the court says, no, Dana doesn't have capacity, then the court will decide who will make decisions for me. So when I do a power of attorney, I have the authority. I have the power to choose who makes decisions for me. If it gets to a guardianship proceeding, the court is going to make that decision for me. In Virginia, we have guardianship and we have conservatorship. A conservator is appointed by the court to make financial decisions and deal with my estate. The guardian is appointed to handle all other day-to-day decisions and medical decisions, residential decisions, and those sort of things. But it is a two-part process in Virginia. They're often done at the same time, and it's often the same person is appointed, the guardian and the conservator, but they are two separate court orders. You'll have a court order for guardianship and a court order for conservatorship. Why am I spending so much time talking about alternatives and then really throwing in guardianship as a last little thought and in the last few minutes? It is the last resort. It takes away basic rights. It's the most restrictive choice. In the legal world, it's often referred to as a civil death because you lose most of your civil rights when a guardian is appointed. One of the most important ones for a lot of the folks I work with is the right to vote. And the next slide, we're going to start talking about all the rights that are lost when a guardian is appointed. There's also some stigma involved because you're going to court and having people talk about what you can't do. They may be talking about every mistake that you've made to show the court that you can't make decisions for yourself. That can be very humiliating. It almost always requires an attorney, which is expensive. I mean, even if you get an attorney that gives a reduced rate, it's still going to be in the thousands of dollars. It's often unnecessary and permanent. Hey, if we do what we're talking about here and we put things in writing, even for someone who has an intellectual or cognitive disability, remember the capacity level to make these decisions, to decide who can be my agent and a power of attorney, capacity level is really low for that. So you can do that and avoid guardianship. Allow the person to maintain their civil rights, allow them to choose who can make decisions for them, and allow them to make their own decisions that they are capable of making, rather than taking all of that away just because they need help making some decisions. Once declared incompetent or incapacitated, these are some of the rights that you lose: making medical decisions, deciding where you live. You cannot get married or divorced. without your guardian's approval and without the court's approval. You lose the right to vote. Anytime you sign your name to something, you do that because you have the legal right to do so. Anybody who's been declared incapacitated, signing their name means nothing. It no longer has any legal authority. You can't make a will or an advance directive. I had to put these on 2 slides because there are so many. So here's the next slide. If you have a will, you can't change it. If you don't, you can't make one. You lose the right to drive. You do not have the right to possess a firearm. You can't buy, sell, or rent property. If you have a conservator, you can't decide how your money is spent. So all of these things go away if a person is declared incapacitated. And these are just the ones that I did on the top of my head. I'm sure there are others out there in the law. So I have to talk about this. Is guardianship always a bad thing? Absolutely not. It is a tool in the toolbox. I do believe it's the last tool we should pick up, but it is a tool and it is absolutely necessary in some situations. There are folks who have never had capacity. They've never been able to communicate in a way that we can understand what their decisions would be for healthcare and other life decisions. And given the medical technology that we have today, we don't think that they will gain capacity in their lifetime. Guardianship is absolutely a good decision there to help people make those decisions. So we talked about why we're doing alternatives. It's inexpensive, it's easy. Attorneys usually not necessary. Again, keeping attorneys out of your life is a good thing. A power of attorney does not have to be registered with the court, so you don't have to get the court involved at all. These are resources. This website here, dlcv.org, supported decision making, that's where you're going to find those do-it-yourself documents that I talked about with line-by-line instructions. I tried to make it so that I'm talking to you through the whole thing, telling you this is what you do here, this is what you do here. VirginiaAdvancedDirectives.org, they have their own forms and whatnot and information. ConnectVirginia.org, that is the free state registry. So once you have your advance directive, you can register it with them and they'll send you an ID card. The Department of Behavioral Health and Developmental Services, they have a supported decision-making webpage that is excellent and has all kinds of good information on there. So these are resources for you guys. One final thing that I want you to always remember is that capacity is presumed. And it is so important that I say this because working with folks with disabilities, especially those with mental health disabilities and those with cognitive and intellectual disabilities, this often stands on its head that incapacity is presumed. Someone sees a diagnosis, they see somebody with an obvious disability that affects either their mental health or their intellectual ability, and they just assume the person does not have capacity. We as advocates, we as parents, and we as people with disabilities have to inform and educate folks that capacity is presumed. This is my contact information and the information on dLCV. And I think I allowed enough time for questions. I'm going to stop sharing my screen if that's okay.
It sure is. Dana, thank you so much. I don't know how many folks here also heard us talk about supported decision making earlier this week, but hopefully you heard a lot of consistency and overlap. I feel like some of these things, when we talk about big concepts like decision making authority and capacity itself, are overwhelming. Like layering some different voices on that are very, very important. I wanted to get folks to chat in and ask any questions that they had. Just toggle them into the Q&A button. Dana, one of the things that we caution families a lot about, and I didn't know if you wanted to speak to this, is talked about multiple professionals or a court professional giving that verdict on capacity. Much like you ended with talking about presuming capacity, we don't often see that as the standard. The law is incredibly clear, as you discussed, about presuming capacity and working to help make someone understand decisions to make sure we're communicating with them in the way they know best. We often see, I'm trying to think of the way to say this, signatures signing off on someone's lack of capacity based upon a medical professional who sees someone once a year for a physical and doesn't ask any questions about capacity, or an attorney who does poll tests and says, who's the current president? Why
Right.
is it important to vote? Right, things that we don't ask your average 18-year-old before we preserve their right to vote. Do you have any advice for families if they really are struggling? They feel like they really do want an outsider's opinion on capacity, someone who may be able to actually help them sort through that. I always feel like families are the experts. You know, at your level and
Yes.
communicates and talks about things, because professionals do have that bias, right? We see a lot of that signing off on lack of capacity without what I would call a substantive consideration and evaluation.
Yes. I do recommend that it be a psychologist or someone at that level who understands capacity evaluations. I will often use like if someone has a guardian and they no longer feel like they need a guardian, I'll use a letter from their doctor that says, "Hey, I know this person and they don't need a guardian. They're making decisions on their own." So a doctor that really knows the person and understands their ability and disability is fine. Um, but you're right. A lot of times doctors, number one, they see individuals for 2 or 3 minutes, we don't get a lot of time with our doctors. And they may not have any experience working with people with disabilities. And so if they ask a question and the individual can't answer the question in a way that is quote unquote normal, using verbal language, being eloquent in what they're saying, and they can't do it in the 30 seconds that the doctor allots them to answer the question, then, they may be found incapacitated when in fact they're not. It goes back to that 3-part process to determine capacity. We need to give people information in a way that they can understand it, and we need to be able to listen to them when they're communicating it. And so I do recommend that if a capacity evaluation is needed, you're looking at a psychologist or someone at that level who does have experience in doing capacity evaluations. And remember, in Virginia, it requires 2 doctors to say that I lack capacity. So my treating doctor may say, Dana does not understand this, so I'm not letting her make this decision. By law, he has to get another doctor to meet with me, and it has to be in person. And that doctor has to say, no, Dana does not have capacity. So it takes 2 doctors to decide that.
Something else we get a lot of, I think, fear-based questions about are things to the tune of, if I don't get guardianship, my child could sign up for a credit card and rack up thousands of dollars in debt, sign up for 15 leases at various apartments, right? They could do all of these kinds of things, which I suppose is technically true. And, I usually follow on, have you seen a tendency toward this behavior, those sorts of things. And the great majority of time, the answer is no. What do you share with families as they're navigating with some of that fear that we all fear as parents as our children approach 18, but especially as parents of kids with disabilities? We are trying to prepare for every worst case scenario. How do we get ourselves out of that scary mindset and really think about the actual right and appropriate decision-making authority, not relying on guardianship to save us?
Yes. So a lot of times every time someone says, I want to become guardian of, and it's usually my child, I want to become the guardian of my child. My first question is why? What is it that you need to protect your child from? And a lot of times I get behavior. I get answers that go back to behavior. A common one is, well, he's 18 now and he really likes girls, and I'm really afraid that he's going to start having sex, and he doesn't really understand that he's not mature enough, and guardianship is not going to do anything about that. Guardianship does not control behavior. Another one I get is, well, he doesn't want to follow the medical recommendations. He doesn't take his medication. He doesn't follow the diet he's supposed to follow. He won't go to medical appointments. Guardianship will not do anything for any of those things because guardianship does not control behavior. So that's one thing to understand. Another fear thing that I hear is, Well, my child is very gullible and he would go along with anything. And, he would even confess to a crime he didn't commit if he thought that's what the adults wanted him to do. Guardianship is not a get out of jail free card. So if someone has a guardian, they can still be convicted of a crime, because when we're talking about incapacity in the guardianship realm, it's totally different when we get into incompetent to stand trial. Those are two totally different things. They are not related to each other at all. So someone can still be convicted of a crime even if they have a guardian. So those are some of the fear-based things that folks will talk to me about: assigning the leases, giving away all their money, those sort of things. Again, a guardianship can be a defense in those things. You can then go back and say, hey, he didn't really have the legal ability to do this because he's been cleared incapacitated, but it's not going to change the behavior. It's not going to, it is not a behavior, what's the word I'm looking for? Management tool. So,
See a lot more of is people being more likely to be victims of scammers,
yes,
right? It's less likely that someone's going to navigate themselves to a bajillion different apartment complexes and sign a
yes,
bunch of leases, and no one's going to raise a flag. No one's going to catch this in a credit check or those kinds of things. But guardianship doesn't, just like anyone, if you're scammed, you're scammed. There's
you're
no
scammed.
undoing that
Yes.
and getting the money back from illegitimate
Yes,
sources.
exactly, exactly. And there are other ways to protect the individual. I've seen parents be very creative in, like, they'll have their child will have a bank account, and the child has a bank card, but there's a limit on how much can be taken out per day. And so, their friends can't clean out their bank account because maybe they can only take out $30 a day. Maybe, they've worked with the bank and that's the limit on that card. Um, Also, really starting early, talking to over and over and over again. Because a lot of times repetition is what's going to be most effective. Talking to people about, hey, when a police officer asks you a question, your only answer is, I want an attorney. And over, if a police officer ever, takes you into a police station, you say, I want an attorney, I want an attorney. Don't ask for mom, because that's not going to get you anywhere, because once you're 18, you don't have the right to have mom in the room with you. Or repetition on, if somebody asks you for money, say, I need to talk to somebody before then. I need to talk to my big brother before I can do that. I need to talk to mom before I can do that. Repetition, 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 and start early on under, so that it becomes um, uh, routine for them to be able to answer questions that way. I mean, those are some ways to I think protect folks, um, other than guardianship and conservatorship. And here's the thing: the courthouses aren't going anywhere. They're always going to be there. And so we don't have to start with the most restrictive option. We can try some of these other things to protect our loved one, and from, exploitation and whatnot. And if it doesn't work, and we've tried two or three different options, courthouse is always there. You could still go to the courthouse and become guardian or conservator, if those other options don't work. What we're advocating for is that you try the other options.
I say much easier to amp up than it is to scale down. We
Yes.
have a good question here coming in. If a person appoints an agent, right, outside of guardianship, but with a power of attorney or something, and signs a contract without the agent's knowledge or involvement, what happens then?
Depends on, so when you're talking about a financial power of attorney, it depends on how it's written. And I know lawyers, we always say it depends, but that's the answer here. So normally when I have a power of attorney, if I'm capable of making that decision, I don't have to have anybody else make that decision with me or for me. However, if I write the financial power of attorney and it says, in order to be legal, it has to be co-signed by X, then I've kind of locked myself into that. But otherwise, if I'm capable of making the decision, then I make it, and it doesn't matter if my agent agrees with it or not. When you're looking at a healthcare power of attorney, the agent has no authority whatsoever, until I've been declared incapacitated. So if I go to the doctor and am making my own decisions, the doctor will never, should never ask the agent, hey, what do you think about this? until I lack capacity to make those decisions for myself.
Does that play in, Dana? And I'll ask the follow-up question for this family with like a general or a durable power of attorney.
So in Virginia, all powers of attorney are durable unless you say otherwise. So by durable, it means it doesn't, okay, so if I say a power of attorney is durable, it means that I write it when I have capacity and it does not become invalid when I lose capacity unless I say otherwise. So for a healthcare power of attorney, it really doesn't come into play because the agent only gets authority when I lose capacity. When I'm looking at a financial power of attorney, there are times when, say, I have a really big estate and I want to say, I want Lucy to be able to have the authority to sign documents on my behalf, buy and sell property, all this kind of stuff. But I don't want this to be durable. If I'm not capable of doing this and keeping my eye on Lucy and making sure she's doing the way I want her to do it, then I don't want her to have that authority. So that's the difference between durable and non-durable. But if in Virginia, if it doesn't say that it's non-durable, it is durable.
Great to know about. Any other questions from folks? I know we've just got a minute or two here left. All right, so as a reminder, if you're watching this either live or recorded on the Padlet that Diane Monig has sent out, we'll be able to share the recording from today and the slides, and on a separate resource-based Padlet, she's got a lot of information on legal authority options. This is one of the things in life that I feel like has got to be completely customized to the individual that we're talking about, right? There's no decision tree you can follow. There's no template that works perfectly for everyone. So absolutely read and evaluate those things, but know in many ways as the parent, though sometimes we have our parent goggles on where we're way overly concerned about our kids and overprotective, you often do know your child or young adult the best and are in the best position to figure out, is there ever been a way that we can convey information successfully to them and successfully get information and answers back out? And, using that as a jumping off point for deciding where to go from there. Dana, I wanted to thank you for coming. Yeah.
I just want to say that this is a very basic. I do this in a 2-hour presentation, cover all of this information. So this is definitely basic. I highly recommend you go to our supported decision-making webpage. We have some wonderful videos and fact sheets and videos of parents who have made these decisions and how they made the decisions and whatnot. So very helpful information. So check it out.
Thank you all so much for joining us today. We look forward to sharing these resources with us, and always feel free to reach out with questions, right? We're happy to help navigate and share things. Have a great day all.